Welcome everyone, this is Tim Pullman and you're listening to the SEP Couch. This podcast is all about standard essential patents. We talk about patent strategies, FRAND licensing, patent pooling, and patent litigation. So let's dive into today's episode. He is the founder and partner at ABE Partners. I'm very, very happy today to have here on my SEP Couch, Takanori Abe, right with me. Hi, Takanori. It's great having you.
Hi, Tim. Thank you for the invitation. It's my great honor.
Same here. It's an honor to having you here. You are a great expert in the field of SEPs, and in particular with your focus, of course, on the Japanese market. And you are the founder and partner of your own law firm with your own services worldwide, as I understand. So maybe to get started, I ask every guest on my SEP Couch, how did you get in touch with the world of SEPs and FRAND licensing? How did you first get in touch? What does your career look like?
Okay. Our firm specializes in the intellectual property and the international business transactions. And recently, as the SEP litigation becomes very hot in the whole world, some of the foreign clients begin to ask us who have interest on the SEP litigation in Japan to understand how SEPs are treated in Japan, especially how the court judgments are in Japan and the recent hot debate at various ministries. And they have a great interest on the reports of the ministries which were issued recently. That's how I am working with them.
Great, very good. And you as a law firm, can you maybe elaborate on what kind of services you provide? Is it also licensing support? Is it litigation? What kind of service is ABE Partners offering?
Yes, we are the litigator, so we do the litigation, and also we do the transactional works. We do the licensing, drafting, negotiations, and among the intellectual property for the patent litigation, we have covered the fields of IT and telecommunications, electronics, machinery, and also pharmaceuticals, chemistries. And we have involved in the global litigation in Japan, in the United States, in Europe. And also we have experience of representing and advising multinational and domestic clients.
Interesting. So you have Japanese clients and international clients, but your focus is the Japanese market, or is it, right away global?
Yes, exactly.
Very good. Great. Maybe let's dive into some more specifics. And I'm really excited to learn a little bit more about how SEPs are litigated in Japan. And you are clearly an expert here. And there is one case that, or two cases that basically touched on SEPs. And I know you had some comments on these cases. One was Apple versus Samsung. The other one was Sharp versus Tesla. Could you maybe elaborate on these cases and what the subject was and how the decision, or if there was a decision even, ended up?
Yes, sure. The team, you are very correct that we only have two SEP lawsuits so far. Actually, in detail, there is unfair competition law case regarding FRAND declaration, but that's not the pure patent infringement case. So you're very correct that we only have Apple versus Samsung case and Sharp versus Tesla case. And Apple versus Samsung case, the judgment was rendered in May 2014. And we have the IP High Court, Intellectual Property High Court, as a second instance court, which held as follows. The IP High Court says regarding the injunction that injunction will be deemed as an abuse of right if a party who intended to make and sell products pursuant to the UMTA standard was successful in proving that the patentee made FRAND declaration and the party intended to obtain a license under FRAND declaration. So it means that the injunction cannot be allowed against the willing licensee. And regarding the damages, the IP High Court said seeking damages within the royalty under FRAND condition will not be deemed as an abuse of right unless special circumstances exist, whereas seeking damages that exceed a royalty under FRAND condition will be deemed as an abuse of right unless special circumstances exist. and the latter is to avoid the hold up. And in both cases, injunction and damages, the IP High Court said the finding of the unwillingness to obtain a license under FRAND condition shall be made strictly. So, the case I mentioned, the unfair competition case, which was rendered after this Apple versus Samsung judgment, followed this holding that the unwillingness to obtain a license under FRAND condition shall be made strictly. And the another case, Sharp versus Tesla, the Sharp in January and February and March of 2020, he filed the patent infringement lawsuits against Tesla Motors Japan in the Tokyo District Court. And we are very curious whether the same thing happens as in Germany, because we are very surprised to hear that the German courts, Munich and Mannheim courts, let Daimler lose, because Daimler is such an important company to Germany. So Tesla is not a Japanese company, but if Tesla lost against Sharp, then next will be a Toyota or Honda. So we are very curious about the outcome, but they quickly settled. So we don't have the judgment. So we don't know how the court's attitude on this very important issue. And we are keenly watching whether another battle will happen in the near future. So these are the two cases appeared in the Japanese court so far.
Understood. And I think your comment is interesting that you said Sharp went up against Tesla, but what if, you know, the automotive industry, which is really strong in Japan, is next, right? And maybe that was even a strategic move from Sharp to go to a foreign car manufacturer first. I mean, just my observation, but I'm reading that between the lines of your answer, maybe. Very good. Thanks for.
I think that's a very good insight. I agree with you.
Very good. Thank you, Takanori, for explaining both of these cases. My take of this, looking at this, is that you know, there have been two decisions, or one decision and one settlement at least, and we'll see if there's more soon. But one thing that I did read in the Apple Samsung case, there's even a number there, a royalty at $100,000 US, but I couldn't make sense of it, and maybe I didn't read it right. Can you elaborate on what this $100,000 US refers to? Is it, you know, is it a certain portfolio they pay for? Is it a yearly license? Do you have some insights on that?
Yes, sure. Of course, everybody is curious how this number is reached. And the IP High Court was clear that they used the following formula to reach this number. The formula was as follows: the amount of the sales multiplies blackened percentage. We don't know the number, but the percentage of the UMTS standards contribution to the sales. And then multiplies 5%, which is a cumulative royalty rate. Because in that case, in this Apple versus Samsung case, both parties agreed to use 5% as a cumulative royalty to avoid royalty stacking. And then divide by 529, which is the number of SEPs indispensable for UMTS standard. And then the ultimate number become 100,000 USD, and which seems to be a low number. And the standard was, as I explained, it's a UMTS standards. And the actual SEP, which declared essential, was 1,889. But the court did not adopt this 1,889 by saying that in general, the number of the patents which is deemed as essential is excessive. And also the report, there's an evidence issued by Fairfield. The report says, in this case, the number should be 529. That is why the court used 529, not 1,889. And because the percentage of UMTS standards contribution to the sales is blackened, so nobody knows what this number is. However, there is a lawyer who calculated and estimated the ultimate royalty in this case is, and he concluded that it could be 0.0023%. 0.0023%, which is quite a low number. Right. So many people criticize this low number, but some people defend. And this is why this Apple versus Samsung judgment is deemed as on the implementer side.
Right. And it's also a top-down approach, I could say, right? That was used here.
Yes.
Setting a threshold, royalty, aggregated royalty, and then looking at the share of the patent holder as to what that is. Interesting. And it was only UMTS. It wasn't a multi-mode 2G, 3G, but it was just for UMTS, right?
I think so. Okay.
Interesting. Well, thanks for elaborating on this. That is an interesting observation. And yeah, I would say also that number is really low, the 0.002%. As I did see some numbers from US rulings that were considered FRAND, much higher, also in Germany. Very good. I think one thing that really is something different in Japan than maybe in other countries is that there are several governmental organizations that have created expert groups that have produced reports that should provide guidance on what a FRAND rate is and how SEPs should or should not be licensed. And you know, can you elaborate on these governmental initiatives from the JPO, the MEIT, and explain a little bit also the role of these governmental organizations and basically also what the reports say that they publish on guiding through FRAND and SEP licensing?
Yes, Tim, you are very correct that Japan is unique in this regard, that there are lots of reports issued by the governmental ministries. So there are several. First one is the Japan Patent Office JPO's Manual of Hante. Hante is an advisory opinion for an essentiality check, which was issued in published in 2018. And another one is also Japan Patent Office Guide to Licensing Negotiations Involving Standard Essential Patents, published in 2018. And then next is the Ministry of Economy, Trade and Industries Guide to Fair Value Calculation of Standard Essential Patents for Multi-Component Products, published in 2020. And then thereafter, Cabinet Office issued the report of Intellectual Property Promotion Plan 2020-21. And then the Ministry of Economy and Trade and Industry published the interim report in 2021. And let me introduce briefly about these. First, the JPO's Manual Hante E, the advisory opinion for an essentiality check. The JPO has Hante, the ordinary Hante, which is, although JPO is essentially deciding about the validity, in Hante system, they decide about the infringement. But for this Hante E, they decide about the essentiality check. So they started this service. But even after this service, nobody had ever used the system. And my observation or analysis is that for the SEP holder, both parties, SEP holders and the implementer, both dislike the fact that they use the system to be public. It will be known by the public, so they want to make it confidential. And for SEP holder side, it may not have value to use this because essentiality is only one issue. There are other several issues which they have to deal with. So even if SEP holder wins on this essentiality check in JPO, that doesn't mean that they will ultimately win everything. So the incentive may not be strong. Then about the implementer, well, it's opposite. So if implementer wins on the essentiality check, that will give a good influence on the outcome. However, this is not a court judgment. So even if there's a good Hante result for the implementer, the SEP holder who received a negative opinion, they still can file the lawsuit and have a good outcome in the court. And also, if the implementer use the system, that will invite the SEP holder to file the lawsuit against the implementer. I think this is the biggest reason why implementer doesn't want to use it. So there is zero case so far, unfortunately. And the next is the Japan Patent Office, the guide to licensing negotiations involving standard essential patents. In this guide, Japan Patent Office tried to give some guidance how the negotiation in good faith should be. But because in Japan there are no court cases on this important issue, what JPO guides did was introduce many foreign judgments in Europe and the US and introduce them, and then they caution that they are not trying to give guidance to the future judgments, but they just introduce, and if the parties follow all these, then it could be useful. That is what they did. And then next is the Ministry of Economy, Trade and Industries, the basic concept. They were very clear, unlike JPO guideline, which was on the neutral side, which introduced both sides' argument equally. The Ministry of Economy, Trade and Industries basic concept was on the implementer side, obviously, because they proposed that the following three principles for calculating the fair value of SEPs for multi-component products should be. They said the principle one is the parties to a licensing agreement should be decided based on the concept of a license to all. And principle two, royalty should be calculated using a top-down approach. And principle three is royalty should be calculated based on the proportion of the SEP technology contribution rate to the value of the main product that implements the SEP technology. And the next one is the Ministry of Economy, Trade and Industries interim report. This is an interim report, so they are not very clear on the direction they are making. And they just say that they have to consider the measure to deal with the SEP disputes, because there should be many SEP disputes in the very near future. And they have to propose the rule for the SEP litigation licensing negotiation processes. And this is an interim report, and the discussion is still ongoing, even in this March. So they may issue another report soon, where they may have a clear position. But in this, the attendees' statements made it clear that this study group is intended to establish the rules that could be considered by the future courts, because they said that the JPO's guide to licensing negotiations, which I just introduced, they kind of criticize that the JPO's guide is equal. Then the judges, it is difficult for the judges to use it. So to be used by the judge, our proposal should be clear on the one position. So they are clear on this stance. And the final one is a cabinet office plan. This is not specific for SEP, but for IP in general. And they proposed future IP strategies in 7 key points. And one of them is a promotion of the strategic use of standards for dominant market expansion. And here the cabinet office said that the Japanese companies are currently lagging behind the competition to acquire SEPs in the areas including 5G technology. And so in particular, beyond 5G era, the Japanese companies should try to acquire SEPs. That is what they observed and proposed. And I have introduced the reports from the JPO Cabinet Office and Ministry of Economy and Trade and Industry. And the JPO reports and the Cabinet Office reports are deemed as neutral, I believe. And but the Ministry of Economy, Trade and Industries report will be deemed as on the implementer side. It may be because that the JPO and the Cabinet Office is not representing either side. And also, after Apple versus judgment I introduced, JPO actually tried to introduce a kind of compulsory license in ADR system. But it was highly criticized because it is against the SEP holders' interest. and then they gave it up. Then thereafter, the JPO issued this guide, and that is why JPO had to be neutral or on the both positions, not on the one side position. And that is why this JPO decision guide is deemed as neutral. But Ministry of Economy, Trade and Industry may be different. One of the important role for the Ministry of Economy, Trade and Industry is to protect the industry. And so I think the Ministry of Economy, Trade and Industry try to protect their industry. And currently, because many Japanese important industries are on the implementer side, that is why Ministry of Economy, Trade and Industries reports are deemed as on the implementer side. That is my observation.
Very, very interesting. And some very good points you have here and insights, Takanori-san. Thank you so much. Also on the anti-system of claim charting, I think that is also something that other policy people are also suggesting, at least here in Europe, to have a centralized claim charting decision maker. But I understand it was highly unsuccessful in Japan. I understand very well the reasons. Maybe can you elaborate on the METI principles again? Because I've read in one of your papers that also a former High Court judge, Mr. Shitara, has been citing on these principles. And maybe also for our audience who are not maybe in all detail understand what license to all means, or top-down approach, or proportionality rule, which you are right, which are protecting the implementers, and which is poison for any SEP holder that I know when they hear just the words. Can you maybe elaborate of what the issues here are and why a license to all right now has been discussed in the German automotive industry with Continental and things like that, but has been denied so far?
Mm-hmm. Yes, yes, you are very correct that these three principles, especially principle 1, license to all, and the principle 2, top-down approach, will be deemed on the implementer side. The principle 1, license to all, means that an SEP holder must give a license to all entities who wish to obtain the license, regardless of their transaction stages in the supply chain. The opposite idea is access for all. It is because the Japanese companies who believes that only they have to talk with the SEP, the patent holders. They feel it's unfair, and all the supply chain should be the entity who should talk with them. That is why they propose the license to all should be fair. And the principle 2 is it is a top-down approach, and the opposite idea is bottom-up approach. And if you use bottom-up approach, then the extreme situation may be that the royalty will be higher than the final product's price, which is, of course, super unreasonable. So to avoid the royalty stacking, to have a ceiling, this is called the top-down approach. In the principle 3, the contribution rate, the royalty should be calculated based on the portion of the SEP technology contributes, or contribution rate, in the value of the main product that implements the SEP technology. Here, unlike the principle 1 and 2, this report did not adopt one idea. Actually, there is a debate between the smallest sellable patent practicing unit versus the entire market value. However, this report emphasized that the contribution rate, what contributes is the most important. But I believe that it won't be the entire market value. So overall, these three principles can be deemed as on the implementer side.
Right. Now, thanks for elaborating on these, Takanori, to get more insights. And just to explain that maybe also in simple words, license to all would be that, also a supplier of an automotive company would get a license, right? Which is right now with some patent pools and set up in the US, like Avanci, is not the case, right? They only offer that to OEMs. So The suppliers don't get a license. They get access through the OEMs, and that would be the opposite, the access to all, but they don't get a license. And that's interesting that this is in the principles. Thanks for elaborating on this. And maybe that is a great introduction to the next question, actually. You know, Avanci is a patent pool that tries to find a alignment between the automotive industry and the SEP holders. And they started this a couple of years back. As I said, it's only targeted to automotive OEMs, but they have set a certain price, $15 for multi-mode access to 2G, 3G, 4G, and eCall. And they have been, especially in the past years, quite successfully not getting a lot of SEP owners as licensors, but more and more companies are also, the licensees are signing up. Just recently, Volkswagen in a second sign up has now all their cars licensed. However, I don't see any Japanese companies being licensees in the Avanci pool yet. And that kept me just wondering why that is the case, because those companies are under pressure, right? They are litigated, maybe not in Japan, but in other courts worldwide. You have any idea why that is?
That's a very interesting observation. And I don't know the exact answer, but there's a statement by the Japan Automobile Manufacturers Association, who says that the Avanci's license terms are not clear compared with the traditional patents. They compared the Avanci's license terms with the traditional patents, and they said that the differences are that Avanci's license terms, for example, does not commit on the having the patent list, and the royalty amount is unclear, and they don't require the essentiality check. So that is why they criticize in this way. And also, the electronic company is one of the electronic companies says they doubt that whether the SEP technology's value in 5G is so high, and he or she believes that it is because Avanci's promotion is good, not because of the actual situation of the technology. And the most of the necessary service for the automobile users are already materialized in 3G. So that's why they believe that Avanci's they doubt on Avanci, and your observation that no Japanese automotive OEMs are joining the Avanci's currently.
Interesting. Well, I just wonder, what if they switch off the 3G signal, which I keep hearing they will do that in a couple of years' time. Then there's only 4G, 5G left. But again, okay, interesting observation, and thanks for hinting and pointing to that statement. Going back to the Japanese auto industry, I still think they are really under pressure. I mean, there is a current litigation, Honda and Toyota, I think it's in Texas. And there will be more, I guess, if they don't start paying for something they clearly use in practice. Some point they have to pay a royalty. I haven't seen, as we discussed before, only 2 SEP cases in Japan. Do you think there's any reason our SEP holders, you know, thinking that maybe the Japanese court system is too implementer friendly? Is that why the court system hasn't been used for many SEP cases? Or what is your take on this? Is it not so simple?
Mm-hmm. Well, this is a very difficult question. And yes, the biggest reason may be that the SEP holders, especially the foreign companies, are having a kind of a misunderstanding on the Japanese court system at the current stage. It is true that the Japanese courts are anti-patented. The winning rate was low, and the invalidation rate was high, and the damage amount was low, like that. But reform has been done, and nowadays the winning rate become higher, and the invalidation rate is already under 20%. So it's quite low, and the damage amount become higher. So we can say that because of the reform, the Japanese courts are pro-patent oriented. But the foreign companies who studied the Japanese situation 10 years ago understand that Japan is an anti-patent jurisdiction and then lost the interest already, and they don't follow up the recent situation. I think this may be the biggest reason why the foreign, especially the foreign SEP patentee, they do not litigate in Japan because they may think that once they litigate, their patent will be invalidated. Well, we don't know how the future court will treat this SEP litigation, whether the IP judge's attitude towards SEP litigation is the same for other cases in general, which is more on the patentee side. We have to see it, but I can clearly say that in general, the Japanese IP judge's attitude has completely changed from a decade ago. So I think there should be a reconsideration for the strategy.
Okay, I see that as an invitation to litigate more SEPs in Japan again. It's just bad PR. Interesting. Thanks for that observation about the Japanese court system and its efficiency, also for SEP holders to work. One other thing that I've been observing, which I found also very interesting, is that Japan has set up a so-called SEP study group. And I know about this group because I think a year ago, I was invited as an expert and I was able to present in front of the group. My understanding is that group meets on a regular basis. It's experts from the industry, both, but also governmental organizations, which I find a really exciting initiative. And I think it's something that maybe other countries should do too. What do you know about this SEP study group? Are you a member of it? Can you elaborate on this?
Yes. Yes, the members are for example, Japan Business Federation, Japan Intellectual Property Association, Japan Electronics and Information Technology Industries Association, and Japan Automobile Manufacturers Association, and Japan Chamber of Commerce and Industry. So very important organizations. And they are discussing the measures preferable for Japan. And as I have explained, they are very clear that their reports should be considered by the future courts in the future judgments. So as I said, they believe the JPO's guide, which is on the neutral position, cannot be used by the judges because they are not clear on which position the judge should stand. So that's why they are discussing the position which is preferable to their position, and hope that it could be used by the court in the near future.
Very interesting. So also here, providing guidance to court decisions on the SEP FRAND matter. And I found that group very knowledgeable, by the way. I think they have a great group of experts there. I have received great questions, and I thought that was a great initiative.
Exactly, they are the experts. Yes.
Yeah, and that's good. I mean, having all the experts in one group on one meeting, I think that is always very valuable. Great. Everyone is talking about 5G is going to be a game changer, right? Everything will be connected, the smart energy, the smart factories, smart homes, smart healthcare, also beyond the auto industry, really, and for sure beyond the smartphone industry. And Japan may be lagging behind, being not, one of the strongest SEP holders in 5G, but how do you see what will be 5G, or that, revolution of some people call it even, with 5G look like for Japan? And what do you think is Japanese position for the next generation 5G?
As a consumer, of course, this is a very fascinating thing. But regarding the SEP concept, as the Cabinet Office plan clearly said, that Japan is lagging behind. So already, unfortunately, Japanese company is not so good in here. However, they are aiming in the beyond 5G era to acquire SEPs. And Japan has many good technologies. For example, NTT and IO1 Global Forum, they have an excellent technology who are supposed to be the patentees in the beyond 5G era. So we are hoping that many excellent Japanese companies will or acquire the SEPs in beyond 5G era.
Interesting. So they're building already for 6G then, and trying to put a more dominant position there. Very, very interesting for that outlook, Takanori. My final question, as always, your elevator pitch, your final statement of what you want to keep the people remembering from that podcast episode today with you about Japan, Saps, and FRAND.
Yes. As I have explained, there are many Japanese governmental or agencies reports. So if you are interested in the Japanese situation, please keep watching the outcome of these reports. And also, although these reports, especially the Ministry of Economy and Trade and Industries reports, are on the implementer side, the suggestion for the SEP holders, especially the foreign SEP holders, is that, as I have explained, that Japan is in general or pro-patent oriented jurisdiction. So, and there is a misunderstanding about the current situation. So Japan can be a good jurisdiction to file a lawsuit. So there is no need to avoid, and the consideration of the strategy, reconsideration of the strategy is welcomed.
Great. That has been really enlightening, Takanori-san. Thank you so much for joining this, getting all these insights from the Japanese court systems, legal systems around FRAND and SEPs. Thank you for being here on my SEP Couch.
Thank you very much. It is my honor to be the member of this very prestigious podcast, which I enjoyed very much. Thank you.
Thank you so much. You have a great day. Goodbye.